Good afternoon. Yeah, I watched that real closely. I guess I can take the privilege of saying that I'm one of the over 1.68 million reasons why you're on here this afternoon. As a person who's directly impacted, I mean, I have been convicted of a felony offense before in the past. And like many others, I have moved on after I have served my time. It got bad for me at one point where I was on drugs and homeless and standing in front of railroad tracks waiting on the train to come so I could commit suicide. The train didn't come. I crossed those tracks, checked myself into treatment. After that, moved into a homeless shelter. And while living at the homeless shelter, I enrolled at Miami-Dade College, and I was able to graduate at the top of my class in paralegal studies. Continued my education and pursued a bachelor's degree in public safety management with a concentration in criminal justice. Because I figured I had enough experience getting locked up on the streets, so that would help me out in my studies. And it did. Graduated at the top of my class again, and eventually was accepted in the FIU College of Law, and in May of 2014 I graduated. But in spite of all of this, I still cannot vote. I cannot even practice law because I can't even apply to the Florida bar until my rights have been restored. And so there are other many collateral consequences, but I sit here today as an example of why the Ravens deserve a second chance.
Thank you.
Hello, everyone. The ACLU has been a long-standing, fierce defender and protector of the right to vote. We have done that successfully and effectively in the courts, we've done it in the legislature, and we've also done it in the streets. I want to put the following in context for you briefly. I know that the other panelists will speak to this, and hopefully we'll have opportunity to go into details. There are 6.1 million individuals who are disenfranchised nationally. 4.7 million of whom are back into the community, living lives, looking for second chances, but unable to fully participate in the democratic process. Florida is one of 3 states, worst states in the nation, in disenfranchising individuals. As Desmond mentioned, there are 1.68 million individuals who are disenfranchised in Florida, and should we have the opportunity, well, when we get the amendment passed in November of last year, about 1.5 million individuals will be able to get their rights restored. That is significant and important. Nationally, there's a patchwork of states in how they restore rights to individuals. We have Florida and Iowa and Kentucky, the 3 worst states. But we also have Maine and Vermont that doesn't disenfranchise individuals. And we're here today to talk about what we need to do in Florida to re-enfranchise the 1.5 million individuals who will be eligible to get their rights restored. Thank you.
Thank you. Sean?
Thank you. So I represent District 61, not 16. I just wanted to make sure we got that right, in case you wanted to vote for me for re-election. So I wish I could cede my time to Desmond, to be honest, because when this changes in Florida, when this constitutional amendment gets on the ballot, you're looking at the architect of it and the person behind it sitting right there. So I'm glad you all recognize Desmond. This is a fight Desmond's been fighting for a long time. We all know about it now. We all read about it now. It's on Facebook and social media. Desmond's been doing this a long time. And it's important, and everyone's going to speak on their perspective. The hypocrisy is what really infuriates me about how we do not treat a person as whole once they are done with their time. We tell everyone that once you've done your time in the system, we want you to be reacclimated into society. When you don't allow someone to vote, that is the most basic, fundamental right that you have as a citizen. And when you're not given that right, you're not reacclimated into society. And how do you think that person feels when they're walking around and can't vote? And can't participate in the democratic process, can't decide who their elected officials are, can't decide referendum, and can't vote. that's an insult. And you're telling that person how you really feel about them, even if they're out of jail, even if they're done with their punishment. And that's wrong, and it's hypocritical, and it's evil, and it's also political. And we need to recognize why why the disenfranchisement continues. It's moral reasons, but it is also overtly political, and that's unfortunate.
Thank you. Andrew?
So we're witnessing the evolution of criminal justice in this country. In recent years, we've hit the critical mass of people coming from both sides of the ideological spectrum to recognize the failed policies of the past generation. Criminal justice reform is all about accelerating that evolution to a smarter, more effective justice system. And criminal justice reform isn't about a particular policy or program. At its heart, it's about an idea. The idea that we have to consider the long-term consequences of what we do every day in the system. How do we build safer, stronger communities in the long run? How do we reduce crime and recidivism in the long run? What is the long-term impact of conviction and incarceration on an individual, on a family, on a community? And let me pause on that last one. The impact of conviction. Because most people who come through the system, I hate to tell you, are coming back into our community. The vast majority of people, whether they have a long prison sentence, a short prison sentence, no prison sentence, after conviction are back in the community. So the question is, what is the system doing to facilitate a smooth and effective transition and reintegration into the community, not just for that offender, but for the entire community? From a criminal justice standpoint, this is about breaking down barriers that make it harder to successfully reintegrate people into the community. And from a position of fundamental fairness, this is about giving people back their rights after they've paid their debt to society.
Thank you. Reggie?
It's a pleasure to be back home. I grew up in West Tampa, 5 minutes from here. There are too many mentors of mine in the room to start naming folks, but I've had the privilege of doing executive clemency cases before 4 governors and numerous members of the Florida cabinet, including your very own distinguished former chief financial officer and state fire marshal and my friend Alex Singh. Today, many of you knew my dad, Skip Garcia, God rest his soul, was a deputy fire marshal under 4 treasurers, starting with Tom O'Malley and ending with Tom Gallagher, but Alex was kind enough to sign his hat for me today. Executive clemency is the governor's constitutional power to grant mercy. That's what it is. And that's why Desmond's group, which has been working since 2014, has to do a constitutional amendment to change how that is done. So it's not a city ordinance, it's not a state legislative statute, that the legislature does have a little bit of a role under Chapter 940. The 1.7 million convicted felons in Florida have lost 4 very valuable rights. The most important in what we're talking about today is the right to vote, but it's also the right to serve on a jury, seek elected office. Many of your citizens who are offering themselves for elected office, thank you, and firearm authority. So executive clemency is the governor's constitutional power to grant mercy. He or she can say no at any time. If he or she says yes, he needs 2 members of the cabinet to join him in that effort.
Thank you.
Okay. All right. So, members, if you are ready to ask your question, go ahead. We have a brand new member today, Gene Suda. Congratulations. Thanks for joining us.
Thanks, Rob, for coming. The 8th Amendment to the Constitution prevents cruel and unusual punishment. So it's not restoring rights, I believe, is cruel, but also unusual within the country. I think we're one of 3 or 4 states that don't automatically restore rights to felons. So is this something that at some point the Supreme Court will just say, okay, this is enough? Is someone bringing this up to that level other than just within the state?
Okay, Rachel, we'll start. Who's got the mic? Rachel, we'll start down the end, and we'll go down this way, if that'll be easier. Rachel, you have it first.
There is a federal lawsuit in the Northern District of Florida that raises some of these issues, particularly due process. that quote unquote that it's free form and there's quote unquote no standards. I think there are some standards. The governor and cabinet has, number one, what the Constitution says, to an extent what Chapter 940, which the legislature's put in, says, and to an extent the 6 criteria that are in their rules. The governor and cabinet have the power to grant new rules at any time for any reason. In the current rules say that you must wait 5 years from the conclusion of prisoner probation, whichever is last, before you can apply for restoration of civil rights for most crimes, and those can be done without a hearing. If you have done one of the 35 more serious felonies, you must wait 7 years before you apply. I'm not an expert on federal constitutional law, but some of those issues have been raised in the last year in the Northern District, and it just hasn't gotten going yet.
Andrew?
So whether it's by legislative change, constitutional revision, or through the courts, something has to change. Florida is among the most punitive states in the country. We effectively disenfranchise permanently anyone convicted of a felony. One of only 3 states that does that. And we also have the highest rate of disenfranchised citizens in the entire country. So college football season is upon us. We'll soon be watching the Florida Gators vanquish all their SEC opponents. And as we watch those games, keep in mind that Florida disenfranchises more people than every other state in the Southeast combined. 1.6 million people. This is a huge problem, as I said before, and it comes back to fundamental fairness. But for the most violent crimes in our community, once you have committed the crime, you've done the time, you've paid your debt, you should be allowed to move forward to become a productive, contributing member of our society.
Thank you. Representative Shaw?
It's a basic hallmark of American society, what Andrew just said. When you're done with serving your time, you should be done. And here in Florida, we're the worst state at it. But to your question a little bit, there's a reason why we're trying to get it in the Constitution, because it has a very different effect when it's in the Florida Constitution than if the legislature is trying to do something. For example, with Desmond's help, I filed a bill that would have prevented your rights from being taken away at the front end, other than for serious crimes. Take a while to guess how many hearings that got, right? 0. So there's a reason why we need Desmond's group to get it in the Constitution so that we can do it, but people can do it. Because I'm certainly afraid that us in Tallahassee aren't going to do it, as you can tell by the experience of where my bill went.
Thank you.
I'm not an attorney, so I can't speak to the Eighth Amendment right. But what I can say is that the reason why we have not made any movement in the state is because the Constitution, as it exists now, gives permission to the governor and his cabinet, his or her cabinet, to disenfranchise individuals permanently. There have been attempts to address it legally, and the intent was not to set back legal precedent, so we did not pursue it. But there's also the attempt to fix it at a federal level through Congress, through the Democracy Restoration Act, making it possible for individuals who have lost the right to vote in presidential elections only. Clearly, we have not seen a fix, whether it's at the federal level or at the state level, and that's why we need the amendment on the ballot, and we need a 60% vote to ensure that it gets passed, and we fix this problem permanently, and not have to defer to whoever is in government going forward.
Thank you. Desmond?
This might shock a lot of you, but constitutionally, there is no express right to vote in the federal Constitution. Understand that. It's not there. When it comes to voting, that power is left to the states. And they're able to decide, and they could stop anyone from voting, all right? But there are penalties that they would have to pay as far as the portions of representatives that can actually be in Congress. But there is no constitutional right to vote in our U.S. Constitution. So that in itself creates this debate that we have throughout the courts about whether or not voting is a right or a privilege. And whenever the courts are applying a standard that voting is just a privilege, then the burden of proof or the level of scrutiny is much lower, and the states are allowed to use policies such as this. Whenever they decide that voting is a right, then that's a higher level of scrutiny. It's called strict scrutiny, and in that way, the state would not be able to survive under the challenges. But in these courts, the level of scrutiny has been lower than the strict scrutiny.
Thank you, Desmond. Hold on to the mic. We'll take the next question. Identify yourself.
Betsy Hapner. Thank you all for all being here. I'd like to know what each of you panelists envision in terms of exceptions to the restoration of all of the rights for those convicted of felonies. Obviously, it runs the gamut. Do you each favor restoration of, say, violent career criminals, those convicted of capital crimes? What restrictions or exceptions do each of you favor? Thank you.
That's a great question. Desmond, you can take that.
So favor and envision is two different things. So I'm going to go with the envision, right? And I use my sons as an example. I have 4 sons. And those of you who have boys know that sometimes they do some boneheaded things, right? It make you want to scramble. So what were you thinking? But no matter what your son may have done, they never stop being your son. And that's the same thing when we talk about citizenship, right? When you are a citizen of the United States, you might make mistakes, but no matter what you've done, you should never ever lose your citizenship. We have 2 states that believe in that, and no one ever loses their rights. Now, when it comes to what we have to do as far as with the amendment, what we know is that because of our polling and our testing, we understand that the public is not ready yet to let murderers have their rights restored automatically. They're not ready yet to have felony sexual offenders have their rights restored. And so we're moving forward. But ideally, everyone, Mr. Warren said that these people are coming out. So no matter what they've done, if they're coming back into our community, we must give them every opportunity to successfully reintegrate, because it's to our benefit that they do.
We believe in second chances, and everyone should have the right to vote. The reality, as Desmond mentioned, that's not the case in Florida. Ideally, yes, we would like to see all individuals be able to get their rights restored. And in reality, you don't lose your right to vote just because of a criminal conviction, i.e. separating that out. But in our society, we do intermingle voting with a criminal conviction. So our goal is to ensure that we do get this amendment passed that will at least minimally restore voting rights to nonviolent offenders. And as has been mentioned before, we're talking about 1.5 million individuals who would be eligible to get their rights restored. So in the ideal world, you shouldn't lose your right to vote because of a past felony conviction. And as mentioned, 2 states, Maine and Vermont, you're not disenfranchised, period. But the reality that we're dealing with in Florida is such where we start with the individuals who have nonviolent offenses.
It sounds like you would want to say people that have committed capital crimes ought to be jumping through extra hoops. That sounds like a good position to take. I don't agree with it, and it's because they also have the end of their sentences. There's also a time when they're out of prison. There's also a time when they are back into society. At that time, you ought to get your rights back. You shouldn't be sitting at your house, not in jail, not able to vote, even if you've committed a capital offense. And I understand there's some heinous crimes that can be committed, but once the criminal justice system, once you're done with that, once you serve your time, that ought to be it. That's what we're talking about here. So regardless, if you're in jail for 30 years, that first year you get out, tell me why you shouldn't be able to vote at that point. I just fundamentally believe once you're done with the time, you ought to be able to be reactivated to society.
Thank you. Andrew?
We want to put reasonable limitations on people's ability to get certain rights back. And we're talking about voting rights, but keep in mind that there are rights in addition to voting rights under the civil rights that are forfeited upon a conviction. The right to serve in an elected capacity, the right to serve on a jury, the right to own and carry a firearm. So the question is, what are the worst offenses? And we have a list of forcible felonies in the state of Florida. We're talking about capital crimes and rapes, which, to Representative Shaw's point, often people don't even complete their sentence in probation, because the probation period is included, in time for them to have their rights restored. But the question we have to ask is, where do we set the limit on this? And are there certain types of people for whom we never want to give certain rights back? And for rights to own a firearm, for rights to serve on a jury, those are rights that for capital criminals and career sex offenders should be forfeited.
Thank you. Reggie?
Thank you, Betsy, for the question. The amendment, I think, strikes a good balance. It exempts murder and felony sexual offenses. And there's a political reason for that. Keep in mind, and only in Florida, we passed a constitutional amendment a few years ago that said future constitutional amendments, like Mr. Meade's, have to pass with 60% of the vote. Remember, medical marijuana first time got 58, and the second time got 71. So just so you know what's going on here between now and February 1st, I mean, Desmond's group for 3 years has spent time picturing the person with a clipboard out in front of Publix, but other community meetings. As I understand it, the ACLU has now said we're going to put $5 million into this so that there's paid signature gatherers, which is really the only way to do it. And they have till February 1, I understand, to get almost 800,000 signatures, and they're less than 100,000 now, and then it has to pass with 60% of the vote to be on the November 2018 ballot. So I think the current amendment, Betsy, good question, does strike a good balance, and it's politically realistic. Even that is going to be a heavy lift to get A, the signatures, and B, the 60%.
Thanks, Reggie. Hold on. Just hold on the mic. I have another gentleman here.
My name is Mark Flores. My question is that since there have been studies that show very unequal sentencing in Florida based on race and poverty, is there a legal or constitutional basis for a challenge to this law? Similar to the challenges to like drawing voting districts, based on race, poverty, and factors like that.
Thanks, Reggie. You have it first.
I defer to the state attorney and others, and you can look up this federal lawsuit in the Northern District of Florida that's been filed by both a national group and a Florida group that raises due process issues. That goes to a larger question of are mandatory minimums good or bad? The legislature could do more, but they've been doing good work. At the urging of some state attorneys, more diversion, civil citations, property crimes, small amounts of marijuana. Let's not create any, we're talking about how do we fix the felons that already don't have these rights, and that's a big part of it, don't get me wrong. But it's also the pipeline. Today, we know all of our prisons are in lockdown. I don't know why. There's something going on in our state prisons today where our 56 prisons are in lockdown. We have 97,000 state prisoners. 1/3 of those are leaving in the next year. That's a good thing. Think about 3,000 a month. And our 67 county jails and sheriffs are sending them 3,000 new customers. We have 3,000 folks a month just who are coming out of state prison, who, in addition to voting, need an ID, need a job, need health care, need community and faith support, etc. So I think it's all tied together. But you raise a terrific point about the larger question of mandatory minimums, and what do we do to keep more people out of jail or folks with more fair sentencing? And that's why folks like Andrew and his counterpart in Orlando and their counterpart in Jacksonville, why we have 3 new state attorneys in Florida out of 20, because those criminal justice issues now are becoming, frankly, somewhat apolitical, which is a good thing. The biggest criminal justice reform folks in the country, you ready for this, are the Koch brothers, who we know from different issues are libertarian and Republican, but they don't think government does this well. So we spent $2.5 billion doing state prisons, and 1/3 to half are coming back in the next 3 to 5 years. So it's a bigger issue.
Thanks, Reggie. Warren?
So this has been litigated somewhat. There was a case filed in the federal court in the Middle District here in Tampa after the 2000 election challenging the voting laws and restoration of voting rights. The district court found that there was no issue with it. The 11th Circuit Court of Appeals actually found that there was an issue with it. And what they held was that they found the rights, the law as we have it now, or at the time, traced back to 150 years of discrimination. from Reconstruction through Jim Crow. The 11th Circuit ended up throwing out the law, and en banc, the entire panel ended up switching it back. However, the en banc panel also found that the law traces back to 150 years of discrimination. The law hasn't changed much since then, even with the 1968 changes in the Florida legislature. So, with that long windup, where are we now? We have a law in place on the books today that the 11th Circuit Court of Appeals twice has found was motivated by racial bias. And it's still on the books today. What are we going to do to change that is the next question.
Thank you. Representative Sharp.
We need to have a whole nother panel on your question. And your question is, and I'm going to, they've answered your question pretty well, so I'm going to go somewhere else. It's the reason I don't support the death penalty in any form for any crime. The inequity in sentencing, the inequity in representation, the inequity throughout the system that pervades the system, that is, any study will tell you it exists, is the reason that I don't support the death penalty. I believe it's applied in a racially biased manner, a gender biased manner, a class biased manner, and for that reason I don't support it. There are heinous crimes committed all the time, but there are also people who are constantly being exonerated. 20 years ago, we didn't have DNA. And so our system is not perfect, and so to exact the ultimate punishment on the system that's just oozing with that kind of inequity is not something that I would ever support. I would never support anything that has mandatory minimums, either, for the exact same reason. Okay.
Thank you.
I'd like to focus on a different angle to this issue. The ACLU has made a national commitment to reduce the prison population by 50%. We are doing that in several ways, through litigation, through legislation, and of course through advocacy. We have been working for decades on addressing the school-to-prison pipeline. And presently we have made a significant financial investment nationwide, but especially in Florida, to reform the criminal justice system. Now, there are several members of the ACLU, affiliated with the ACLU, involved with the ACLU at many levels here today. And I will encourage you, could you raise your hands, please? I will encourage you to talk with them, and we could provide you with details about how we plan to reform criminal justice in Florida, as we are attempting to do across the nation. Thank you.
Thank you, Desmond.
So I believe the name of the case that was referenced by Mr. Warren is Johnson v. Bush. And so that is a definitely good read. But I also want to take a different angle. In that case, especially when you talk about the racial disparity or the disproportionate impact that this issue has on African American communities, it inadvertently created a false narrative, right? And that false narrative has been that this is an African American issue, right? Now we understand where it originated, right? And just like any tumor, it could start in one small spot in your body, but if you ignore it, it grows throughout your body, and at some point you're going to have to address it. It has caused people to believe that because this is an African American issue, it now becomes an issue favoring Democrats, right? It so now becomes a political issue, when in reality, what we're dealing with is that African Americans only account for a third of people who are disenfranchised. So while maybe a little over 600,000 might look like me, there are over 1 million people that look like most of you all here. They cannot vote. And the other point being is that when we always thinking about the people that are incarcerated, Florida only incarcerates about 24